Committee, Ms. Beatty from Ohio for 5 minutes.
Thank you, Mr. Chairman, and thank you for that response to the chairman's last question about the investigation with Act Blue. We know investigations, whether it's Act Blue or the Epstein files, go both ways with what we're looking at and what we read in articles. And I note that we are moving forward looking at the Epstein files as well. But that's an aside. Let me say thank you again, because last year I had the distinct honor of having you in my district with former Undersecretary Nelson for our small business information session on the beneficial ownership rule. At that event, we talked at great length about how critical this information is to law enforcement, and many of them were present in our AML-CFT regime. Let's fast forward to March of this year, and the Trump administration has done a total about-face, violating the clear intent of the Congress to include domestic companies that are not otherwise exempt from the law. In my opinion, they were included because, in fact, there had been crime with the domestic companies. Director Gacki, we applaud you for working across all lines, but my question is, do you still agree that domestic companies could present a money laundering risk?
Ranking Member Beatty, thank you so much for that excellent question. I want to thank you for welcoming me to your district last year. It was a terrific experience to get to interact with your constituents. And I do want to step back and reiterate that as a career civil servant working across administrations, I will implement the policy of the administration as it applies to beneficial ownership information. And I would say for the current administration has taken a look at the reporting structure and assessed that the burdens on small business fell too greatly and needed to be alleviated. And that is what FinCEN did through the interim final rule. However, as you point out, there are still instances where domestic shell companies can be leveraged in financial crime. And there I can point to other sources of information that can help law enforcement if the beneficial ownership information regime is not being used. For example, FinCEN's customer due diligence rule on financial institutions does require collection of information at the point at which accounts are opened. And financial transactions and financial accounts are usually critical to all forms of shell companies in the United States. That being said, we will be carefully reviewing the responses to our interim final rule to see if any adjustments need to take place. As this is an ongoing open rulemaking, I can't discuss the ultimate resolution of that, but we look forward to reviewing all comments on all sides of the beneficial ownership issue.
Thank you. Then let me make this comment, and I'll phrase it versus in a question to what I believe. I believe that it is accurate to say that the Treasury's recent decision to exclude domestic reporting companies from enforcement exempts the vast majority, I believe roughly 99% of covered entities from the reporting rule. Also, I believe that, therefore, this decision to exempt U.S. companies makes it easier for fentanyl traffickers and other criminals to launder money through the United States, endangering the safety of our constituents. Don't want to put you on the spot. There are many who believe that. We have records to show from drug trafficking coming into Ohio and across many of our highways. So let me just say that I'm going to continue to be an advocate against illicit crimes. And if that means us doing due diligence of asking for information about who owns a business, I'm a business owner. You would have no reason in supplying the information, and I suggest to some of my colleagues, if they pull up the form and look at the questions that are being asked, they appear to me to be standard questions that any business doing good business, legal business, should want to do. And thank you, and I yield back.
Thank you.
Thank the ranking